Now, we've had two requests for 3-minute presentations to the commission this morning. Our first one is from Mr. David Lutter. And Mr. Lutter, please come forward and limit your comments to 3 minutes.
Thank you, Mr. Chairman, members of the Commission. My name is David Lutter. I represent the Environmental Defense Alliance, and I'm here today to present you with some new information on the issue of emails. At the last meeting of the Commission, your attorney, Mr. Tambling, informed you all that he was not aware of any statutes or other legal authority that would authorize an agency in any way to restrict or regulate how its members are allowed to use their own private personal email accounts. He then said, so for that reason alone, I would recommend that the Commission not take any action on this proposal. I think Mr. Lutter's best recourse would be to take this matter up with the legislature and have them pass a law requiring it if they so desire. Chairman Miller said, I guess the answer, Mr. Lutter, would be go to the legislature and get them to pass it. Well, not being satisfied with that response, I went back to my office and did some research and found that the legislature has already addressed the issue in the Uniform Electronic Transaction Act. In that act, the legislature gave every state agency that has authority to adopt rules, shouldn't say every, most state agencies, you are not accepted. If you have authority to adopt rules, you may adopt rules governing the manner in which electronic records shall be sent, received, and stored. And you may specify the systems established for such purposes. So you do have the authority to adopt rules regarding the use of email systems and the storage of email. In other words, you could require that all members of this commission use a state email address and that all emails be stored on a state system rather than a personal system. That statute is Exhibit 1A in the handout that I provided. Exhibit 1B is an Attorney General's opinion interpreting that statute. And in that opinion, the Attorney General said the Secretary of State has authority to promulgate rules applicable to online voter registration, where otherwise the Secretary of State statutes did not speak to online activity. The Attorney General concluded that this statute gave the Secretary of State that authority. A couple of other items I wanted to address regarding emails. Exhibit 2A and 2B, 2D and 2C impose requirements on public officers such as yourselves not to destroy or dispose of any public records that you have in your possession. That includes emails that discuss government activity. What that means is that you can't hit the delete button on your computer for a government email without violating these provisions. If you intentionally hit that delete button, you've committed a crime. So wouldn't it be easier to make sure that all those emails are generated and stored in a state system where you don't have to be worried about that. At the very least, you had better maintain a backup system for all those emails. Exhibit 2A is a statute which says that public officers shall accurately keep in and for their respective offices or places of business all records that will afford full and detailed information in reference to the activities or business carried on by such officer. Now note that, well, this statute was probably written back in 1923, so at that time, agencies probably hadn't developed very far, and public officers probably often didn't have a central office such as you have here. But in that statute, it requires that the public records be kept in offices or places of business of those public officers. Exhibit 2B is an Attorney General's opinion interpreting that statute. And in that case, the agency did not have a central office. And the question was, where do we keep public records if we don't have a central office? The Attorney General responded that they should be kept where they will be reasonably accessible to those persons who need to consult them and have a right to see them. That's the public. They should be under the supervision of a responsible person selected by the board. You already have that. You have a central facility here. You have a responsible person who can manage those records. That's where they should be kept. Now, if you were to ask the Attorney General for a formal opinion today, I suspect he would say your records should be kept here at the central office where they can be accessed by the public. But you haven't asked for a formal Attorney General's opinion. An opinion from Mr. Tamling, while I'm sure he exercises his best judgment, is not a formal opinion from the Attorney General. Now, two more things I wanted to mention were that there are several sections in the code that talk about public records of former public officials. Exhibits 2E, 2F, and 2G address those. 2E says when a public official vacates his office, he has to turn over all public records to his successor. Exhibit 2F says that the successor to a person who has vacated their office has the right to demand of the predecessor in office that he turn over public records. And 2G says if a person dies in public office, the successor to that office can demand of any person who has custody of those records that they turn over those public records. Now, I won't imagine, Mr. Miller, I believe your predecessor in office was Comrade Pierce. I could be wrong, I believe that's the case. Did he turn over his public records to you as his successor in office? Mr. Walters, you're the professional engineer. James Lair was your predecessor. Did he turn over any public records to you? Right. Did either of you or any of you ask your predecessors to turn over to you any public records in their custody? I mean, that's something that ought to be done as a matter of course. These are public records. They're going to be lost forever if you don't do what the statute suggests that you do. Lastly, exhibits 3A and 3B are publications of the Department of Archives and History. That department is responsible for advising agencies about records management, and it's responsible for collecting and keeping public records once their use is kind of been minimized. But they do provide advice to agencies. I would certainly encourage you to contact them about your emails. In these two documents, Exhibit 3A and 3B, they both say that they encourage official government email accounts to be used in the conduct of public business. Of course, they can't require it, but they do encourage it for obvious reasons. These are public records. They have to be preserved. They go through pretty extensive detail about the fact that emails are indeed public records. And as long as they address government activity, they are public records. When I say public records, I'm not talking about records that are exempt. Well, I am talking about all public records. But calling something a public record does not mean it's not exempt from disclosure. It can still be exempt from disclosure. But regardless of whether it's exempt, it's a public record and has to be maintained, preserved, not destroyed. So don't hit the delete button. You may be committing a crime. Thank you. If there's any questions, I'll be happy to take them.
Thank you, Mr. Love.